Mediation bill and approach this debate today with a view to actually see how best we can contribute towards strengthening the bill. And I see the member from Northeastern St. Andrew looking at me quite keenly. And so I wish to make it clear, Mr. Speaker, that our intent and our approach this afternoon is not to obstruct, but rather to construct or reconstruct in some cases. Mr. Speaker, we understand and we share the view and the vision articulated.
Welcome to the Pepsi Football Nation.
Understand and we share the view and the vision this afternoon is not to obstruct, but rather to construct or reconstruct in some cases. Mr. Speaker, we understand and we share the view and the vision articulated by the Minister. We agree that mediation is indeed an ideal course of action to heal the wounds that divide our society. We note that this bill actually goes extremely far, not just deals with mediation here at the local level, but also encompasses international mediation. Against that background, it is important that we view this bill, Mr. Speaker, with a critical eye and to see how best we can lend our various expertise into making this bill as robust and strong as we possibly can. And so against that background, I trust that the House will be minded to view my suggestions and my recommendations in the spirit in which it is intended, Minister. And I start with the interpretation clause of the bill. At page 4, clause 2 speaks about, forgive me, Mr. Speaker. Clause 2 speaks about an individual who is habitually resident in Jamaica being permitted to access mediation under this particular bill. And I'm referring to the section that defines domestic mediation. Domestic mediation is actually defined as relating to a dispute arising out of a legal relationship where a party is habitually resident in Jamaica, amongst other things. My suggestion is that we should amend this particular clause to substitute ordinarily resident instead of habitually resident. And my position, Mr. Speaker, is very simple. In legal terminology, as the Minister would know, the test to establish whether an individual is habitually resident in Jamaica is a much stricter legal test that needs to be satisfied, as opposed to where an individual is simply required to be ordinarily resident. And the truth is we have a number of Jamaicans who divide their year into living here in Jamaica for part of the year and another part in another jurisdiction. By this definition, we would be precluding and excluding those categories of Jamaicans from being able to benefit from this act, or rather from this bill, because we are insisting that they must be habitually resident in Jamaica. And so my suggestion, Mr. Speaker, is that the word habitually resident be amended to instead reflect ordinarily resident. And that can be carried over into a similar provision at page 5, clause B, which also makes reference to habitual residents. My rationale is the same. Secondly, at clause 11.2, I'm not sure if there was an oversight or if it is that we intend to embark on a course that is being pursued by some more modern or advanced democracies. But I note that we have created a summary offense at clause 11.2, but the penalty is only stated as being a fine. It doesn't include what should happen in default of payment. And we do understand that not everybody will have the funds to pay $1 million. And so I'm of the view, Mr. Speaker, that it is good practice, Minister, and we've traditionally done this in our legislation where the default prison term is actually included in the specific act. And so my suggestion is that we should make a decision as to whether we are going to be consistent, because in the other provisions I note where there is provision for a fine, a maximum fine of $1 million, in default 6 months. Here at 11.2, there is no provision for what should happen in the event that the fine is not or cannot be paid. So my suggestion is that that clause also be amended just to include what should happen in default of payment. At clause 12.1a, it speaks to eligibility to become a mediator. And I note that in order to qualify to be registered as a mediator, one needs to have attained the minimum age of 21 years old. I'm of the view that in this modern dispensation, that age limit could appropriately be reduced to 18. And the reason for that is very simple. And it's not just because some of us are more mature at 18 than some 21-year-olds are, but it is about equality before the law. And I note when I look at the entire bill, there is a schedule, Mr. Speaker, the 4th schedule actually allows for mediators qualified in other countries to be allowed to practice as mediators here, even if they are below 18 or under whatever age they're allowed to practice that in their country. They can come and practice in Jamaica. And at the same time, you would have Jamaicans who would not be able to practice as mediators because they have not attained that age. So as a matter of equality before the law, and also if we are looking at seeing how best we can assist, especially those younger ones with employment opportunities, this is a nice way to transition them into formal employment. And so my suggestion and recommendation is that we reduce the age from 21 years old to 18 years old. And finally, and I've given this one some thought, but I am hopeful that we might be bold and transformational. One of the biggest challenges that we've had in the justice system centers around the backlog. And yes, we appreciate the strides that the Chief Justice, the courts, and indeed you as Minister, forgive me, and indeed the Minister has actually done in bringing our numbers down, but we're still not where we need to be. We still have a 54% case backlog as it relates to civil court cases. My concern, Mr. Speaker, is that this bill provides that once a mediation agreement is signed, one party has to go back before the court to apply for it to become a binding court order, so to speak. My view is that we don't need to reinvent the wheel. There is ample precedent in our neighbors in the Eastern Caribbean, for example, where they have an automatic conversion model that allows for once a mediation agreement is signed, it is automatically converted into a final order issued out of the court. So there's no need to formally go back before the court, apply for it to get that particular status. It automatically converts upon registering the mediation agreement in court. In other words, all you have to do is file it in the registry. There's a specific registry designated for mediation agreements. Just like you have probate registries, etc., you have a mediation registry, an expedited registry. Once you file the mediation agreement in that registry, it automatically takes on the legal weight of a final binding court order. That means that individuals don't have to go back before the court if there is a breach of the mediation agreement. It means that you're not contributing to the backlog and you're actually seeking and implementing ways to speed up justice. And so, against that background, those are my brief suggestions for the improvement of this bill, and I hope that this House will give due consideration. Thank you.